So parties have agreed on a contract, they've specified the terms. Now there's a problem. A dispute happens between the parties and they're arguing as to whether certain terms are more important than others. That's why we need to understand how terms are classified, especially by the courts. And that's the whole purpose of this video. So not all terms in a contract are considered to be equally important. You would have the more important terms, or the ones that we refer to as the essential promises, and legally they would be referred to as conditions. On the other hand, you'd have the less important terms, or the non-essential promises, and these would be referred to as warranties. It's important to differentiate between conditions and warranties, particularly when it comes to remedies. So a dispute takes place and a breach has happened. That breach, was it a breach of a condition or a breach of a warranty? And whether it was a breach of condition or a breach of warranty, it would impact the remedies that the injured party can receive. So when it comes to deciding on whether a term is a condition or a warranty, the court would look at the facts of the case. So it will observe what the facts were in the case, and then based on that, it would make a decision. An important question that the court would ask is, what was the impact of the breach? Did the breach of that term, did it deprive the injured party of a substantial benefit that it was supposed to receive? And if the answer is yes, then that term would be considered as a condition. If the answer is no, then the term would be considered as a warranty, the less important promise. So for conditions, it's important to realize how a term would be labeled as a condition. So if the party would not have entered the contract if it weren't for that term, then most likely that term would be found to be a condition. And the authority case over here is this New South Wales case. A term that reaches the heart of the subject matter of the contract is classified as a condition, generally speaking. As I said, the importance of differentiating between conditions and warranties lies in the fact that there are different remedies. So if a condition is breached, the injured party would be entitled to sue for damages, but it can also terminate the contract. On the other hand, if a warranty was breached, then the injured party can sue only for damages. So there's no termination that's available for the injured party if it is a breach of warranty.